manslaughter after a drunk driving accident killed one of his friends. As punishment, instead of 10 years behind bars, the judge sentenced Tyler Allred to a decade of attending church. Well, predictably, the ACLU is now blasting that decision as unconstitutional, saying it blurs the line between church and state, does it? Let's bring in our legal panel on this one. Defense attorney, former prosecutor Keisha Hebron, and trial attorney Kirsten Wilson. Kirsten, let's begin with the basics, and we'll put up on the screen the First Amendment, part of it at least. Congress shall make no law respecting an establishment of a religion or prohibiting the free exercise thereof. Now, as drafted, it only applied to Congress. But the Supreme Court says, well, you know what? The founders really meant it to apply to any government action, state, local, whatever. A judge is an arm of the government. By forcing a kid to go to church, does he breach the First Amendment?
Absolutely. He absolutely does. The case law that the Supreme Court has decided based on the First Amendment specifically says if there's state action involved, including the court, and there's any sort of coercive environment, and certainly sentencing somebody and giving them the option of going to church or going to prison, and it involves religion, it's a violation.
Keisha, what about it?
I don't feel the judge is forcing this person to go to church. It's a plea agreement, and as stated in one of the articles that I read, the parents and this juvenile or adult, 17-year-old adult, they agree to it. So obviously he's not being forced to practice a particular religion or to attend church.
And the victim's family agrees to it. Kirsten, even the judge, and his name is Mike Norman, said that his sentence probably violates the Constitution. But then he pointed out this, let's put it up on the screen. Quote, both families were satisfied with the decision, meaning the victim's family and the defendant. I talked to the district attorney before I passed sentence. I did what I felt I needed to do. Now, there's an enormous amount of compassion here in this thing. And if the defendant, as well as the victim's family, everybody agrees to it, what's the problem?
The problem is there's a judge who is using his discretion to determine when he's going to stick with the Constitution and when he's not. Certainly nobody's saying that a deferred sentence under these circumstances isn't an inappropriate sentence. It is a young kid. These kids were friends. And there is, as they said at the sentencing hearing, no reason to destroy two lives by sending this kid to prison instead of giving him some other options. But a lot of the other conditions of the sentence are those types of options that can make sure he stays on the right path. Substance abuse, finishing high school, getting his welding degree, I believe.
Right.
So there are things built in, conditions in the sentence that are going to ensure that he stays on the right path.
Well, and I wonder if the judge is overstating what it is he did in the agreement by the defendant. I'm not sure that the defendant really voluntarily agreed to this. Look, you're standing in front of a judge,
right,
and you're looking at 10 years at the big house.
Right.
You know, 10 years in a stained glass church seems really good. Isn't there a measure of coercion and duress here?
Well, you know what? One of the things that judges do in coming up with an appropriate sentence is that they look at their pre-sentence investigation report. And I'm sure there's something in this defendant's pre-sentence investigation report that indicates this is something that will help in rehabilitating him. I know it's not a juvenile matter, but it's probably fitting his life. And now, I think he goes to church anyway, so.
Yeah, he does. I mean, so he's probably already going, but now he's definitely going to go. But look, the ACLU is aggrieved over this whole thing, but they don't have standing to sue, do they?
They don't have standing to sue, and what they're doing has been done in other cases, I believe in Alabama, where they're contemplating going to the Judicial Conduct Committee and seeking some sort of censure against the judge, because this isn't the first time that this judge has imposed church attendance as part of a sentence.
And you know, Keisha, it's a problem for the judge, I think, because he is sworn under oath to uphold the Constitution, and even he admits that what he did probably violates the Constitution. Right. He could be sanctioned or removed, couldn't he?
And he should not base his decision on the fact that, oh, well, I don't think anyone's going to appeal. Because you're right, he does have an obligation, an ethical obligation to uphold the Constitution. So he went far on a limb on this one.
Although I do sort of applaud him for his immense sense of compassion for this, you know, young man who's brokenhearted over what he did. So, yeah, there's that. Keisha Hebron and Kirsten Wilson, good to see you both. Thanks so much, guys.
Good to see you, Greg.
Okay. Heather?
Well, coming up, we have seen an uptick in high-profile labor disputes.